Hello everybody, this is your mentor Paridhi Tulsian and today we will be discussing about the Place of Worship Act. It is a 1991 act and its essentials are very important for the country like India. Though we all are aware that in India there are different diversities and different places for worship. Today we will discuss all the essential needs for the place of worship. The question comes, what does the Place of Worship Act states? An act to prohibit conversion of any place of worship and to provide for the maintenance of the religious character of any place of worship as it existed on the 15th day of August 1947, that is the independence, and for matters connected thereto or incidental thereto. Here we will be discussing how a conversion of a place or a maintenance of a place which was meant for a particular religion or a character has to stay as it was on the 15th of August. When we here talk about, we have to discuss what is the history of this act. As this act is not a very old act, it is a 35-year-old act which is a 1991 act. Here, on July 12, 1991, a member of parliament for the city of Jangipur in the state of West Bengal introduced a resolution in Lok Sabha titled Steps for Maintaining Status Quo of Religious Shrines and Places of Worship. As they stood on August 15, 1947, before the Places of Worship Act was tabled in the Indian Parliament by the Union government. Here in 1991, at the height of the Ram Janmabhoomi movement, the parliament passed and the president signed into law the Places of Worship, that is the Special Provision Act, where the Congress Prime Minister P.V. Narasimha Rao signed the act into law while the Babri Masjid stood. Now, we all are aware what has happened when it comes to the Ayodhya Mandir, and here we will be discussing more on that. The passing of this act effectively prevent any new concerns involving the alteration of any place of worship from arising. The article analyzed the application of the 1990 Act along with the history of the inception of the Act through different landmark cases. Now, when we talk about the features of the Act, we understand that to ensure the religious building retain their religious character as it existed on the 15th day of August and for matters connected therewith or ancillary. Thereto, the Places of the Worship Act of 1991 makes it illegal to convert any place of worship. You cannot convert any place of worship which was there on the Independence Day. So let's discuss the provisions of this act. Section 2 defines the place of worship, conversion and commencement of this act. They say that any public religious worship structure has to be used such as temple, mosque, gurudwara, church, monastery or any congregation which was there as on the Independence Day. Section 3 whereas say this bars the conversion in full or part or a place of worship of any religious denomination into a place of worship of a different religious denomination or even a different segment of the same religious denomination. In simple language, it will be termed that it should be of the same religious denomination as it was from the beginning. So here the conversion is something which is prohibited. Moving to the next section, section 4 here states that it declares that the religious character of a place of the worship shall continue to be the same as it existed. If it existed as a gurudwara, if it existed as a temple, if it existed as a mosque, it should stay the same. Section 4.2 says any suit or legal proceeding with respect to the conversion of the religious character of any place of worship existed on the 15th of August 1947 pending before any court shall abate and no fresh suit or legal proceeding shall be instituted. If there is any case regarding the same on the 15th day of August, it can still stay. Other than that, no fresh suit can be filed. Section 5 stipulates that the act shall not apply to the Ram Janmabhoomi Babri Masjid case and to any suit, appeal or proceeding relating to it. So section 5 is exempting the Ram Janmabhoomi case. Now moving ahead from here, let's talk about the exemptions which are there. Now the Ram Janmabhoomi Babri Masjid matter, which was under section 5 of this act, says it does not apply to this situated in Ayodhya, which is in Uttar Pradesh, and to any suit, appeal or other proceedings relating to it. So when we talk about the historical monument, it says any place of worship that is an ancient and historical monument or an archaeological site or is covered by the Ancient Monuments and Archaeological Sites and Remains Act of 1958, any dispute that has been settled by the parties or conversion of any place that took place by the acquirents before the act was commenced, a suit that has been finally settled or disposed of. These kind of suits are exempted under the section 5 of the act. Now, this act was somewhere criticized. Let's talk about the criticism over here. The act has been criticized as a judicial review, which is the basic feature of the constitution, and that was barred. Now, it is opined that the abridges the right of religion of other groups like Hindus, Jains, Buddhists and Sikh. Basically, if there is any monument, any historical site and I would like to change it under the same religious domination as well, it will not be permitted. Also, there were lot of tombs, lot of historical monuments changed from one particular religion to another, and that was also not allowed to be reconverted. Now, the principle of secularism embodies by the preamble and the constitution is seen as a violation due to this act. Now, secularism, when we talk about, is the part of the basic structure of a constitution as well. It says that the government will not be favoring any particular religion and all the religions are equally respected in our country. It is also contended that the pilgrimage sites or burial grounds are covered by the state list and the center was therefore powerless to enact regulation in this area. Now, however, the center had maintained the entry 97 of the union list residuary power allowed it to do so. Now, in this, the state, according to the state circumstances, will take this decision. But according to the union list, the center can also interfere whenever it is needed. Now, when we talk about what can be done further. Now, when we talk about the way further, India was not a constitutional democracy until August 15. In the Middle Age, when a temple was supposedly demolished, there was no rule of law. At one point of time, the rule of law did not even exist and the polity had an expansionist mindset. The question was, what is a religious historical monument? What should be taken into consideration when we are considering a conversion of such monument? There was significant difference between the medieval polity and the contemporary Indian state. When India became secular, they started respecting all the religion and all the religious minorities were also given the preference. But now, in a modern democracy, we have constitutional idols and the rule of law. Recent event appeared to be a part of a larger plan to rip the country's social and political fabric to shed by sowing discord among its various communities. Now, considering the Ayodhya matter, it was considered which place of worship is considered for a particular religion and of another one. Now, when we talk about the destruction of the Babri Masjid was deemed illegal by the Supreme Court in the related case, the court ruled that the state has a constitutional commitment and constitutional duty to uphold the equality of all religions and secularisms. The quote somewhere helps all the religion to prevail the right of religion under the constitution and provide equal protection under the same. These are the fundamental principles of the document. Based on its interpretation of the Indian Constitution, the court has ruled the Place of Worship Act of 1991, which is essential to maintain Indian secular character. Decision made by the government, the administration, the court must be based on law and the constitutional ideals, not on emotions or political pressure from the majority. It should not be made a political agenda. It should be considered what is the place of worship and what is the religious importance a particular community is holding on to it. Let's conclude this. The idea of religious equality underlying the Place of Worship Act protects the rights of the people of all faith. Here we are talking about you belonging to any other community, any other religion, your place of worship rights will be protected. It is important to remember the Article 25 of the Constitution, which protects everyone's right to freely practice their religion. Now, when I am practicing my religion, my practice includes going to the temple or the Gurdwara or the mosque. When it comes to matters of faith, one person's freedom must yield to the rights of the others. Thus, the Act implements a constitutional obligation and can in no way be considered as unconstitutional. Now, moving to the Place of Worship Act enacted for a specific cause. The law is a window into our past and our country's potential future. Since we are aware of our past and the need of our country to face it, we can now see the independence was a turning point in the progress of mending the nation's wound. There were a lot of religious fights between the minorities and the other communities which has to be taken care of after independence. Now, taking the law into one's own hand is not a viable option for rights past wrongs. Parliament has issued a clear directives that the wrong of the past cannot be exploited to oppress the present and the future in its efforts to preserve the nature of the public places of worship. So overall, the place of worship according to the religious minority should be respected and should be provided to the religion as accordingly. Here, I would like to conclude by saying respecting under the Article 25, everybody's right will provide you your right to religion as well. Let's conclude this. Thank you so much. Please subscribe to our channel for further such videos.